Thanks everyone for getting on and hopefully, I suppose, enjoying some of these issues that we're going to talk about. It is an interesting set of topics which seem to come up every 2 years, every 4 years when we get into the election season. It's not completely just focused on that, but the election season this year has made this even more sort of a scary Halloween type thing as we move ourselves into October. If you've been watching the polls, all of them seem to be saying that the presidential race, Congress and Senate are close, maybe one vote away, one way or the other. So what we're going to try to do is clarify that, really right now the federal agencies have the baton, and they can rule on many federal cases, hurting even the smallest employers, and that's who, of course, we try to protect. We'll also talk about the current federal rule making that we call it the Chevron case, and why that's important, and even important as we get to the presidential and Congress and Senate races in November. It doesn't go away until they get sworn in. There's going to be a lot of movement in those about 3 months, right? That will certainly affect HCMs and their clients, franchisors and franchisees, which we continuously see that flipping from one side to the next for the franchisors and against the franchisors. So we'll give you again what we do at myHRcounsel, which is really a one place to go to get all of these, either through webinar, weekly newsletters, the blogs that we put in, and of course, as Dan said, you can get a hold of us, our attorneys, and usually in about an average of 11 minutes have your questions and documents that you need turned around. So again, just because the election is coming up and it seems like there's not a lot, maybe in the papers or in the on social media, don't let that fool you, because we're about a month, 41 days away from what we believe will be both federal and state quick changes to rules, depending on, again, how the election comes out. So with that, let me start and introduce my friends, Andrew Nielsen and Mikel Johnson, who are the guys that you want to hear anyways.
Thanks, Mark. And I just wanted to throw out everybody our standard quick disclaimer. This information today is not legal advice. It's for informational and educational purposes only. If you're already our client and you have a question, just go ahead and send it through our portal. If you'd like to become a client, we'll have some information at the end on kind of making that happen. And just as a quick overview before we get into the meat of the presentation, our topics today are going to be political speech in the workplace, which Mark kind of broadly touched on. We're going to speak about non-competes and joint employment. There's still a lot of activity in those areas. We're going to discuss pay equity. We'll talk about some other trends, which Mark also kind of spoke on. And then if we have time at the end, we're going to look at some questions and answers for you in the broad sense of what we're talking about today. Where we generally start looking at, and one of the big questions we get, as Mark said, every couple of years, every 4 years, maybe every year if you've got an off-year election too, is a lot of employers wonder about how to handle some of the political speech that comes up in the workplace. I mean, this can be a hot button issue really at any time, whether it's an election year or not. But in a particularly polarized climate that we're in now, it's really a hot button issue. So what is political speech? Well, it can include things like wearing clothing or other items like buttons, stickers, wristbands, things like that endorse or oppose an idea or a candidate. It can be displaying posters or bumper stickers, and even liking a social media post could be considered political speech. Now, as we talk about what are some, we talk about political speech, or what are some of those risks in the workplace as it relates to political speech. Well, if things get a little warm, you could have some lower worker productivity. Depending on how conversations go, you could have claims made by employees against your company. They could say things like they're being retaliated against, they're being discriminated against, they're being harassed, a hostile work environment is being created. Those are all the kinds of legal issues that can arise for an employer with that type of speech happening in their workplace. And what about private employers? That's what people often ask. I'm a private employer, I'm not a government employer. With that, it's important to note that if you're a private employer, the First Amendment doesn't really apply to you. We've touched on that in another webinar, but the First Amendment is in place to protect individuals from the government limiting speech, not from a private employer who hires employees from limiting speech. As a private employer, you can limit some speech in the workplace, anything that's harassing and discriminatory. One employee to another, they're harassing somebody, they're discriminating. That's not protected. Oh, we're getting a little feedback on the line for some reason. But what is protected employee speech? That's another question that we often get. There is employee speech that is protected that can't really be restricted by an employer. And where we really see that is under the National Labor Relations Act. That's something that we've talked about again on a recent webinar. But the National Labor Relations Act covers both union and non-union workplaces. And it allows both union and non-union employees to engage in concerted activity to better their working conditions and to be able to speak with coworkers about the terms of their employment for their own mutual aid and protection. So employee speech relating to helping each other out, discussing pay, hours, scheduling, things like that, that's protected. And in some cases, that could include a political or social activity if that speech is related back to their job duty and working conditions. What we're seeing right now with the current composition of the National Labor Relations Board, and this is something that Mark had sort of touched on in the intro, is that the board can swing back and forth. The members of the National Labor Relations Board are political appointees, and if there's a change in the federal administration, different people go on and off the board. But what we're seeing right now with the current composition of the National Labor Relations Board is that protected speech in the area of mutual aid, working conditions, things like that, it's swung more towards political statements. So more and more employee speech related to political causes or political statements by the board is being considered now protected, because there can be some connection drawn to working conditions, to wages, to things along those lines. And how do you address this in the workplace? One thing you want to look at is having some policies in place, and I'm going to see if Andrew is there to speak about that.
Oh, I'm here. Can you hear me?
Yep, we got you.
Amazing. You guys were just talking about microphones going out, and then mine magically went out. You spoke it into existence. So yes, workplace policies regarding political speech, and I have some fun stuff on this. Examples. So most employers, and I presume everybody on the line here is going to be a private employer and not a government agency. As such, you're allowed to have policies that prohibit speech within your workforce, in your workplace. And for example, a lot of companies have anti-harassment policies. You can't, call somebody a dumb, XYZ based upon their age, race, gender, whatever. You can have anti-discrimination policies in your workplace that can cover worker behavior along those lines. Anti-retaliation policies. If somebody files a complaint against you, or a complaint in general, you can't retaliate against them. And anti-hostile work environment policies that go along with your anti-discrimination policies. These policies can also address political speech in general. Now, be careful There's different rulings on the state level. I believe there's about 11 states or so that have laws that have some protection regarding an employee's political speech. I'm looking at California, Colorado, Connecticut, Illinois, Louisiana, Michigan, Nevada, New York, North Dakota, South Carolina, and Utah. So those actually aren't all of the usual suspects, California and Illinois and New York, granted, but some of those other states are a little surprising in terms of having laws on this. So when we talk about this, keep in mind about the interplay between federal law and state law. So these policies that employers have can also address political speech. They can prohibit wearing of clothing or accessories potentially, as long as that policy meets National Labor Relations Act requirements. What you need to do is make sure that you have a neutral policy prohibiting wearing all forms of politically themed items that are unrelated to the workplace. But even that isn't going to be a panacea. For example, what if an employee wore a Union Workers for Kang t-shirt in the workplace? Is that protected speech under Section 7 of the National Labor Relations Act? I would argue that it probably is. And so even though you might have a policy that says no politically themed t-shirts in the workplace, potentially that could be a Section 7 right that you're trampling on, and you might find yourself facing an unfair labor practice charge in front of the National Labor Relations Board. It's all going to be very fact specific. There's going to be no guarantee in terms of what is allowed and what isn't just by drafting a policy. You have to take a specific look at what the employee's behavior is based upon the policy that you have crafted and are trying to enforce. Additionally, also subject to the National Labor Relations Board is a non-solicitation policy. Lots of companies have non-solicitation policies. I've drafted hundreds of them, I'm sure, over time, that basically says you can't solicit employees to join the union while they're on the clock and interrupting their work. Those policies, again, have to be narrowly crafted such that they don't trample on an employee's Section 7 rights under the National Labor Relations Act, to make sure that you're not unwittingly getting yourself the nice present of an unfair labor practice charge in front of the National Labor Relations Board. And one thing to keep in mind is all your policies must be consistently enforced. So make sure that, just like with all your policies, that you're enforcing them consistently to all employees across the board. Be particularly mindful, depending on your political bent, of singling out a particular message or candidate for better or worse treatment. For example, saying I prefer the candidate Kang, and so anybody who comes in with Kodos wear is going to be disciplined, but I'm going to allow the other one and look the other way. That, again, is another perfect way to get yourself in trouble with uneven enforcement. In addition to this, the National Labor Relations Act, there's a bunch of other federal laws that get in, that come up and rear their, ugly heads when you're trying to enforce these policies. For example, religious T-shirts or religious affiliation is a protected class under the Title VII that is enforced by the EEOC. So the Title VII of the Civil Rights Act protecting religion, what if somebody came in and had a T-shirt that said Pastafarians, for this candidate? I'll use Kang again. Well, Pastafarianism, theoretically, is a religion. And if you punish somebody for wearing a shirt that expresses their religious views, or punish them for being a Pastafarian, potentially you are running afoul of the Civil Rights Act, Title VII, and could land yourself in trouble with both the EEOC and its state equivalent in your area. So how do you deal with all this? Well, you need to have policies in place in terms of how you're going to accommodate an employee's sincerely held religious practice in the workplace. And you can do that unless doing so is going to create or reasonably threaten to create a hostile work environment under the EEOC. So how do you determine that? Well, similar to an ADA thing, or similar to those that have dealt with this during the pandemic and having vaccination policies, you have an interactive process set up. You know, how does an employee request an accommodation? How do you discuss that accommodation with the employee? How do you determine whether or not that accommodation is reasonable or not? Who makes the decision in terms of whether or not this is an undue hardship? Who makes the decision in terms of whether or not this creates a hostile work environment? So just, you know, on top of just all this political stuff, you know, the NLRB has gone so far as to indicate that some social causes fall under this protection as well. If you've read any of the cases in the last, I don't know, 18 months or so, the NLRB has supported employees' right to wear BLM pins or shirts in the workplace. And so it goes beyond that. You know, what if somebody wears you know, a QAnon shirt supporting James K. Polk, you know, the 11th president? Is that protected speech? Is that an undue hardship? Does that create a hostile work environment? All things that you have to delve into on an individual basis to make sure that you are not running afoul of any of these federal laws and state laws as well. And one other question I'll pose you guys with, and I don't have a great answer on it, but what if somebody comes to work wearing a headscarf, a Palestinian headscarf, a keffiyeh, in support of Palestinian rights, and you have employees in your workplace that are Jewish, and they take offense to that because they believe you know, one thing and the Palestinians believe another thing? How does that resolve itself? I mean, is the keffiyeh a religious thing? I think it isn't, but you should investigate that before you make a you know, an across-the-board declaration. You can't just come up with knee-jerk reactions. You need to engage in the process, and like I say, paper and file to document what you've done, so that you can be sure that you are not going to get yourself in hot water with any federal or state agency along these lines.
Let me just add a couple of practical things on top of that. So in my many years, I've had managing partners who were running for office, or people who were, you know, maybe their husband or their wife was running for office. They were hosting big party and fundraisers for their side of the aisle, if you would. And as an HR leader, and you know, if the owner, for instance, on a small business is the one hosting that, and you know, if you don't go or you don't donate, you know, geez, they're gonna, you know, there's only 10 people in my company, they're gonna see that I'm not there. You know, you have some challenges there, and all I would say is just make sure, you know, open a ticket and just say, here's the issue I have. Do you have, you know, a 2-paragraph, what would I say? How do I bring this up to my my employer? Because just walking in there and saying, you cannot do that, the EEOC, you know, that's not going to work. It's just not going to work. You're going to have to be creative and, you know, again, be cognizant of if it's, you know, if it's their son or daughter that are running, you know, are you telling them that, you know, they can't do this and stuff? And the fact of the matter is, you probably have to say they can't. But you have to do it in a way that you know, it doesn't ruin your progression up the ladder during the day.
And with that, we're going to move on to our next topic, which is non-competes. Now, this has been on the radar of businesses a lot in the last year, and this is something, again, that we have spoken about. But with our trend, or with our topic today of kind of trends that you want to keep an eye on as things move along towards the end of the year, this issue is not resolved by any means. And we'll talk about some of the recent developments here. So the Federal Trade Commission is the FTC that's noted on the slide. They made a rule earlier this year, and keep in mind, they're a federal agency. They are not Congress, but they have rulemaking authority. They passed a rule in April of this year banning most non-compete clauses in employment agreements. This was a very broad rule. This is a very onerous rule if you're a business that uses non-competes. The FTC felt those types of agreements were unfair methods of competition, and thus they thought this is under our purview for our rulemaking, that we can do something about that. The rule was supposed to go into effect on September 4th, so earlier this month, about 3 weeks ago. And it would have been a national rule, again, Federal Trade Commission, federal overlay of all private employers across the country. It would have gone in effect on the 4th of September, and would have required it would have not just affected and effectively banned non-competes, but it would have required notice from the employers to the affected employees. So this was a very big deal, and it had a lot of teeth to it, so to speak. However, the rule was blocked by a court action. A number of businesses and business groups across the country teamed up to stop the implementation of the law, and actually a federal district court in the Northern District of Texas stopped the law and issued basically a nationwide injunction. That Northern District of Texas, that federal district, is known as a kind of a more employer-friendly district. But even with this rule being stopped by this court order and nationwide injunction, we want to tell you today that rule is not yet dead. Legal actions are continuing on this Federal Trade Commission rule. The cases are sort of all over the map, and I mean that literally, in terms of which courts they're in, what conclusions have been reached, what arguments are being made, which parties are involved. So there's a lot of different moving pieces to this. Even though it's stopped right now, that is not the end of the discussion. Some of the courts where these actions are proceeding have sided with the Federal Trade Commission, and some courts have gone against the Federal Trade Commission. And with all these different rulings, it's likely at some point the US Supreme Court could become involved. So this rule, as is, depending on how things play out with these court cases, could potentially go into effect at some point. And additionally, even with the rule blocked at this time, the FTC will absolutely keep pushing on non-competes, including looking into individual enforcement actions against employers if they come across something. So I think Andrew wants to say something about some alternatives to non-competes and just some workarounds to consider.
Yeah, this is always a fun area. Non-competes, restrictive covenants. Restrictive covenants include non-solicitation, both of customers, but also employees. This is something that is governed by each state at the state level. So every state has their own non-compete rules, which you have to make sure that you are complying with. You know, for example, Minnesota, California, North Dakota, and one of the other Midwestern states that escapes me at the moment effectively ban non-competes. Some states are really antagonistic towards non-competes. So Wisconsin, where I am, non-competes are generally disfavored. And if the court finds one thing wrong with your non-compete, they're going to toss the whole thing instead of fixing it or reforming it or editing it. So non-competes can be tricky to enforce. They're expensive to enforce. And so maybe instead you use a non-solicitation agreement, because really what you're trying to do is stop them from poaching your clients. Maybe instead you have trade secrets that you're trying to protect. At that point, maybe a confidentiality agreement is your winning solution here, because you're trying to protect, let's say you're Coke and you're trying to protect the secret formula. Well, you're going to have your employees, rather than sign a non-compete, sign a trade secret confidentiality agreement where they agree that they can't share any trade secrets. Or maybe your confidentiality list, trade secret list, would contain customer lists. Some states, those are considered to be trade secrets, customer lists. So maybe what you don't need is a non-compete. Maybe it's a confidentiality agreement. Maybe it's a non-solicit. All those things vary by state. So again, if you have questions about that, submit a ticket, let us know, because these are tricky areas to traverse. And if you pull up a form from the interwebs, I can pretty much guarantee you that it's going to be of questionable enforceability, to say the least.
Let me add just one thing on that, having been a general counsel as well as these two guys have. In order to enforce a non-compete, you need to enforce every non-compete, typically. Of course, we'll usually, if you pick one and pick another and don't pick the other one, and pick one, and 2 years from now you try another one, in a weird sort of way, there are times in your business where if somebody did go to your competitor, you would not care, especially if they couldn't take your trade secrets, confidentiality, and solicit your clients, and that maybe they were somebody you were, just to be honest, that you weren't that thrilled with their performance, and you still would have to take that non-compete to court, and it's expensive. And so you want to be able to have these choices, and really protecting trade secrets, protecting your clients, and protecting them not taking your employees and starting a competitive business are ways around that courts have typically held up, and they're ones that you typically, if you had to sue to protect, you would be okay doing that.
And similar to what we were just talking about with non-competes, we're now going to move on to joint employment. That is another product of federal rulemaking, not Congress. This is an administrative agency. They do have some power to make some rules. And so the National Labor Relations Board came out and said, we want to really broaden the net of who is considered a joint employer. So they put a new rule in place in 2023 that was supposed to go into effect in March of this year that would have really upended who is considered a joint employer. This rule has been kind of swinging back and forth for close to 20 years. And this new rule that was put out by the National Labor Relations Board said that when one company not only has the right to exert control over terms and conditions of another person's employees, but also if they have reserved, unexercised, or indirect control over working conditions, that would have roped another company in as a joint employer, thus really expanding the liability for more than one company. If you, for example, are an office and you had your fire inspection guy come into the office to do his annual inspection of your fire suppression system, and you had some sort of rule that you had to follow, well, now you're roped in as a joint employer with that fire suppression company. So again, business groups really came out swinging against this legally, and they had a court case filed again in a federal district court in Texas where they got that rule blocked. This 2023 rule was too broad. They got it blocked. So now it's back to the rule that was in place in 2020 of an employer must possess and then actually exercise substantial and direct and immediate control over somebody's terms and conditions of employment. So with the example that we just discussed, now under the current 2020 rule, the fire suppression guy coming into your office and he has to sign off on a policy or adhere to a safety policy, he's not automatically now going to be your joint employer. You're not going to be a joint employer with the fire suppression company, because we're back to a different rule from 2020 that said actually exercise substantial, indirect, and immediate control. The thing that we want to note is that this isn't over yet. Kind of like with the non-compete rule, these federal agencies, they fight on. They keep trying to make sure that they make rules that they like, that they're going to push out nationally. And we're seeing examples of this. There was a recent incident out in the Los Angeles area regarding some Amazon drivers that Andy's going to speak about.
Yeah, the National Labor Relations Board in Los Angeles investigated Amazon and was trying to determine whether or not Amazon was going to be an employer for purposes of the act for a group of delivery drivers. So some of you might know this, some of you might not, but what Amazon does, they have some of their own employees driving around, but they also contract with companies to deliver products that are ordered, through Amazon. The drivers wear Amazon uniforms. They drive Amazon company branded delivery vehicles, and they look, if you don't know any better, if you're not reviewing their employment agreement or their independent contractor agreement, you would have no idea that they're not actually an Amazon employee. Amazon argued that these drivers are actually only employees of the contractor, their independent contractor delivery partners, and they are not Amazon employees. The National Labor Relations Board regional director in Los Angeles found otherwise. That person believes that these people that are working as quote unquote contractors are actually jointly employed by Amazon, and Amazon was found to be a joint employer of those drivers because of the following reasons. And that main reason was that Amazon exerted direct control over the drivers. It controlled how they did their work, what they look like, what vehicles they used, stuff like that. And that control factor is going to be a big key in a lot of joint employment and independent contractor analyses. Joint control, if you look back, pretty much any test on the state or federal level to determine whether or not somebody is an employee or an independent contractor is going to come down to control mainly. And here, Amazon exerted control over the purported contractors by directly firing 2 of those drivers without telling the contracting company. And to me, I think that makes sense. If you are directly firing drivers without telling their purported employer that you're firing people, at that point, I think you've really blurred and probably crossed the line in terms of joint employment at that point. So this finding, however, was under the older 2020 joint employment rule and not the new one that was just shot down by the Fifth Circuit. So that means that the NLRB is saying, well, we don't care essentially that you shot down our rule. We're going to try to find other ways to expand the scope of joint employment. And they went back and they used the old rule to try to expand how they are enforcing these rules. What this does for Amazon is it opens the door for unionization of all their contract employees. And Amazon's going to fight on this. They're going to fight against joint employment. They're probably going to appeal. So we'll see what happens. But right now, Amazon is considered to be a joint employer there. So what can you do to resolve that situation or to avoid that situation, I guess, which would be more preferable? Look at your vendor contracts and see who has control over who and how that control is exercised. For example, using Michael's fire extinguisher guy, if you sign a contract and it says, they can come in monthly or whatever it is and check the fire extinguishers or the emergency lighting, and they can do it however they want. They just probably have to do it during business hours. That's not a lot of control. However, taking it to the extreme, if you state that anybody who comes in to your premises has to do it, they have to wear your company uniform, and you can fire them, without consulting or discussing with their boss, that's probably going to be too far. Now, that's an extreme example, obviously, but those are things that the NLRB is going to be taking a look at when they determine control in terms of independent contractor status. Also, besides your contracts, look at what you're actually doing in reality, in real life. Are you trying to exercise control over these workers? Are you, directing how they do things? Are you providing the equipment for them in terms of how they do their jobs and the tools to do their jobs? Even though your contract says you don't. If you do, you're probably coming close, if not crossing that line. Again, as always, questions about this, hit us up through the ticketing system. Ask us in our portal. We'll help you out, and we'll help suss out which way is up in terms of that joint employment analysis, and make sure that you stay safe. Finally, on joint employment, there's a fun case. Patel v. 7-Eleven came out in Massachusetts. Massachusetts is, in general, a pretty independent contractor-friendly state. They have a broad definition of what is an independent contractor and what isn't. In this case, a group of 7-Eleven franchisees banded together to sue the franchisor, 7-Eleven. So the franchisees claimed that they were actually joint employees of the franchisor, 7-Eleven corporate, and not independent from them. Their argument was based upon the fact that 7-Eleven provided their equipment in support of their operations, and that the franchisees were required to staff their stores and use 7-Eleven branded uniforms, buy supplies from specific vendors, and pay fees to 7-Eleven corporate for the right of operating their franchise. This is a pretty recent case, came down 20 days ago, 2-0, and the Supreme Judicial Court in Massachusetts held that 7-Eleven franchisees operating in this typical franchisor-franchisee relationship were still independent contractors, and they were not employees of 7-Eleven. The court held that the franchise operators here did not perform any service for 7-Eleven corporate and were not the franchisor's employees under Massachusetts law. It's important here to note a couple things. If you are a franchisee, or if you are a franchisor, I guess, too, make sure that your employee handbooks indicate who is the actual employer. I know when I draft these employment agreements, it says that your job is with XYZ company. XYZ company is independent franchisee of ABC franchisor, and I make sure that they sign off on it in the acknowledgement. They acknowledge that they are an employee of the independent franchise and not of the corporate franchisor. It's also probably good practice to put that in your offer letters too, to make it clear who the employer is. So even though that Nielsen Enterprises might be operating a 7-Eleven, those employees are not an employee. My employees of Nielsen Enterprises work for me. They don't work for 7-Eleven corporate. So brand standards in terms of franchise or franchisee cases are going to be your saving grace in terms of getting around the uniforms and the vendor and all that sort of stuff as well.
Next, in the interest of time, we're going to move on to pay equity. And I'll just kind of go through this briefly, but just be aware as an employer that pay equity is a growing trend nationally. The purpose is obviously to prevent pay disparities based on protected class, such as sex, race, age, things along those lines. There is a federal law in place, the Equal Pay Act of 1963. So this issue has been around for 61 years. However, a lot of states feel that the federal law doesn't have enough teeth to it to be enforced when perceived pay disparity issues exist. So what happens then with a lot of these issues is that the states step in and they pass laws that are applicable to employers on specific topics, including pay equity, that put a lot of requirements on employers if you're in a state where one of those laws is in place. So think of California, Colorado, District of Columbia, Hawaii, Illinois, Maryland, New York, Washington, those kind of traditionally more employee-friendly states, but also laws that are states that are maybe less considered employee-friendly are also getting into the act as well. So just keep in mind generally that you want to check when you're posting a position, whether internally or broadcasting it out on the internet, publishing it somewhere. Be aware of if your state has a pay equity law, and if so, what are your requirements? Does it mean pay ranges? Does it mean telling people internally? Do you have to consider remote workers or not? Is the law specifically written to address that? That's an area that we see quite a few questions on, and I would say that if you're looking at opening up a job, you do want to check to see if you've got a pay equity law in place, and ask us. We are deeply involved in this. Some of the laws are newer, being implemented, so reach out to us if you've got a question on that topic. And then we did want to talk about some of the other things to watch. I'm going to go through quickly the cannabis piece. Really what it comes down to is more and more states are allowing or they're decriminalizing cannabis in the recreational space. What that basically means is that somebody can't be arrested criminally for use or possession of cannabis. However, there is an overlay of states that also build in some employment protections. They have legal off-duty conduct laws, and how somebody who maybe tests positive for cannabis, if you're in a medical only state or a recreational and medical state, how does that affect you? Or is there an overlay of a legal conduct law that you have to consider as well? Hey, my guy tested positive, but we've got this law in place saying that off-duty legal conduct such as consumption of tobacco, alcohol, or now cannabis is protected. What do I do with that? Those are some of the issues that we are really seeing a lot of questions on. Also, we're seeing a huge trend with paid sick leave laws. More and more states and then even municipalities are passing paid sick leave laws for employees and paid family leave laws. This again is due to a perceived gap in lack of control or laws at the federal level. So these other government bodies, whether it be a state, a county, or a city, are stepping in and passing these laws that make employers subject to paying for employees' time off. More and more states are adding them. This is something you certainly want to look at and check in with us if you've got questions. And the last two topics we do want to talk about, we may go a little over our time here, but they're important. So I would urge you to listen in, and Andy is going to talk about these last two issues. They're both federal issues, but they do trickle down to all the state employers as well.
Yep. We're going to talk about the exempt employee pay thresholds kicking in 1/1/25, and that's going to be a big jump from the jump that happened earlier this year. So the exempt employee threshold is set to increase from the current level of $844 a week, or $43,888 per year, up to $1,128 a week, or $58,656 per year. That goes into effect January 1, 2025. That's a big jump in such a short period of time. Something you need to be prepared for. I haven't actually seen the lawsuit that's been filed on it, but if it hasn't been filed yet, I'm sure one is coming to try to block it. And I bet you dozen donuts that lawsuit will be filed in the Fifth Circuit in Texas, most likely, to try to block that. We'll see what happens. The methodology for this increase is different than the one they used in July. The one they used in July was similar to the underlying reasoning that the Trump administration used to increase the threshold when they were in office during the Trump administration. This one's different, so it might be more ripe for a challenge, but something to keep an eye on in terms of being prepared to either increase your employee's salary level or to switch them to being hourly. And legal dork out time, Chevron, end of the Chevron doctrine. Most of you probably only know Chevron either as a symbol or a gas station. This refers to the latter. Chevron in 1984 had a case that went up to the Supreme Court, and the Supreme Court said that the courts had to defer to an agency opinion when evaluating an ambiguous statute. So if there's a statute or a ruling that the courts couldn't figure out, they just relied on whatever the agency said it meant. And this has been the rule of the land for, 40 years now. Earlier this year, in the Loper-Bright case, Chevron was overturned. Again, agencies no longer are given deference in terms of resolving statutory ambiguity. Courts do it. So under Chevron, an agency can no longer tell the court what something means, essentially. And now with Chevron gone, judges are going to not have to defer to those agencies unless Congress specifically indicated that they do. This is going to have some big ramifications in terms of cases and rules especially put out by agencies such as the EEOC, the NLRB, OSHA, Department of Labor. There are already cases filed. There's going to be cases, I'm sure, challenging prior decisions that relied on the statutory deference. But basically, Chevron has been abrogated and is no longer required for courts to listen to what the agencies say something means anymore. Interestingly enough, I actually ran across a case yesterday in Wisconsin looking at something else that did a similar thing in, I don't know, must have been 4 or 5 years ago. None of those cases that the old deference was given to LIRC, Labor Industry Review Commission, which is the greatest named agency in Wisconsin as far as I'm concerned, LIRC. None of the LIRC cases have been relitigated yet, where the agency told the court what a statute meant, similar to the Chevron case. So who knows what's going to happen, but if Wisconsin's an example, nothing. But not every state is going to act like Wisconsin. So at the federal level, I expect a different outcome. I expect it to be challenged.
And thanks, everybody. We
And
normally
with
try
that,
to shoot
I
for
think
about.
it leads us to questions.
Yeah, we normally try to shoot for about a 45-minute presentation here. This is kind of important today. The topics we covered, we went through somewhat quickly, but we wanted to keep those on the radar again as trends that are coming out and
Dan, do
things
we have
to be
any
aware of.
questions percolating out there?
And absolutely let us know if you have questions, as Andy just mentioned.
Yeah, we have one question here. It's on joint employment. Are franchises concerned about being considered a joint employer because they provide us with payroll and customer service software? Thoughts?
Yeah, well, let me jump in there. I think that, right now, again, the history of this is the Fifth Circuit has pulled back their appeal. You would only do that if you had another case that was stronger in a different district. I do think probably November 6th after the election that we'll see an NLRB ruling, and whether it's because you have to use a certain system If that certain system has an employee handbook in it, or that is coming from the franchisor, I think that's where you get yourself into trouble. I'll market ourselves a little bit, in this case, is that as a franchisee, because we are not the attorneys for the ZORs, for the franchisors, that as you get a handbook built from us, you have protected yourself from that joint employment. And with the yo-yoing back and forth that has happened over the last 4 years, and certainly will happen over the next 2 and 4 years, why you would take that chance and hope for associations or for district court judges to rule versus having an independent subscription-based attorneys build a case for you and have the best chance of not being sued on that. I don't know. That's going to be up to you, but we have spent a lot of time to try to work around a situation and put a solution in place that wouldn't get you in trouble, or at least would give you the best chance of being successful. As Andy said, making sure that the employee, in your employment agreement or in your offer letter, is very clear that you are in it, that the employee is the employee of the owner of the franchisee and not the franchisor, just starting points like that. So.
Yeah, that makes sense. I would echo what Mark says. We do have solutions in place, and we are keeping an eye on this, folks. We're really watching at all the topics that we've discussed today, even some of the ones we went over a little more quickly. These are items that are on our radar. They are major issues for employers of all sizes, from the biggest ones you can think of down to medium and small employers. We're here to help. If you've got additional questions, absolutely let us know. Contact us through the portal. If you're not already a client, on the next slide here, we've got some information on how to contact us.
Yeah, thanks, Mark, and thanks, Michael. We have one last question for the day. The question is, in the 7-Eleven example, were you referring to the employees at the specific 7-Eleven location or the 7-Eleven franchisee themselves?
I think they're one and the same. The employees of the franchisee were the employees of the specific location that was run by the independent franchisee.
Good question, though. Yeah.
Awesome. And with that, I'd like to, sorry, go ahead, Mark.
Go ahead. I was just going to say, well, once again, it just broadens and confuses, the policies that you have to put into place. All of these things, the Amazon case, my God, that just opened up a big name and just adds to the confusion that you have to draft, in your summons and complaint and everything else. So again, use us for what as to why you have us as a subscriber, is make sure that we put those words in there that we know from the cases as we've read them, those are the right words to get into these documents, and just take advantage of that.